What's up, fellow entrepreneurs? It's John Fagerholm again, and today I want to talk about labor board claims. But first, I'm an attorney, but I'm not your attorney, so please seek out competent legal representation for your specific needs. All right, let's talk about it. If you've been hit with a labor board claim, first, don't panic, but don't ignore it either. So let me break down how it typically goes. Foremost, you have to understand that it's very easy for an employee to bring a labor board claim. No evidence needed, they just need to feel like they weren't paid properly or even just be mad at you. The next thing to understand is that once an employee makes a labor board claim, they're assigned to a person. And this person is likely a volunteer, likely a college student with a humanitarian degree, likely someone looking to save the world, and likely considering law school. Now, I know this sounds like hyperbole, but it's likely going to be the case, at least in my experience. The volunteer then helps the employee fill out an Excel type of spreadsheet claiming all the missed breaks, missed overtime, minimum wage, whatever it is that they're claiming. Now, all of this information is going to be based on the employee's memory and be input by a person that doesn't know to ask the right questions to determine if the information is accurate or even true. That information is then used to make a claim against you for a dollar amount that the employee says they're owed. Sometime after the employee is interviewed, you're going to receive in the mail what's called a notice of a complaint. And in that, it will tell you all of the things that the employee claims is owed to him or that you didn't pay. There's going to be a separate sheet that tells you you have 10 days to respond to this, but the response is not required. And in my opinion, I don't think you should respond, because basically what ends up happening is you provide evidence to the labor board, which is judge, jury, executioner, and they represent the employee. In our legal system, the plaintiff is required to prove their case and prove that the defendant did something wrong. However, in the labor board, the labor commissioner expects you, the employer, to prove you didn't do something wrong. That's the difference between the labor board and our regular legal system. If you don't have the documented evidence and it's your word against the employees, be sure that you're going to end up paying some amount of money. Now, in all fairness to the labor board, they have gotten better. They started hiring law school graduates as hearing officers. In the past, bureaucrats just worked their way up to hearing officers, essentially being judges without any experience outside the echo chamber of the labor board system. Several months after receiving the complaint, you're going to receive a document called Notice of Claim and Conference. This is a very important document and you shouldn't ignore it, because it's the first opportunity to settle the claim without having to go to a hearing. The Notice of Claim and Conference will typically give you a date and time to appear, and most of these appearances, since the COVID era, are either by phone or by video. But some offices may require you to appear in person. Along with the Notice of Claim and Conference, there's going to be a sheet with a number. And you're going to look at that number and say, wait a minute, this is much larger than even what the employee claimed I owed them. Well, that's because the labor board also adds additional penalties and fees on top of what the employee says that you owe. The largest of these numbers is what is typically called liquidated damages. And what that is damages that are assessed for not making the payment when you should have made the payment. And it's typically the daily rate that the employee is paid times a maximum of 30. So for example, if they're paid $100 a day, then you're going to pay an additional $3,000 on top of what the employee claims that you owe. Now remember, this large number is just a claimed amount. Nothing's been proven yet, so you don't necessarily owe this money, and that's why the Notice of Claim and Conference is important, because it's your first opportunity to go in and tell your story. Now, they don't accept evidence at a Notice of Claim and Conference. The employee tells their story, you tell your story, and then the Deputy Labor Commissioner attempts to get you guys to settle prior to going to a hearing. Now, I get calls all the time asking me to attend Notices of Claims and Conference, and I typically don't do it unless the number is so large that it makes sense to do it. For the most part, if the risk level and the number is large enough, you may want to hire an attorney. If not, then go in there yourself. It may be intimidating, but it's a casual mediation style type of meeting, and you just attempt to get rid of it, whether you owe it or not. If you don't resolve the claim at the notice of claimant conference, then roughly a year later, you're going to receive a notice of hearing. At this stage, you typically need an attorney unless the dollar amount is lower than what you would pay the attorney. Then, of course, it wouldn't make sense to do that. Now, this is a full-blown trial. You're going to be presenting evidence, you're going to be cross-examining witnesses, and everything is going to be under oath. So it's really important that at the very minimum, you understand what you're doing in the context of a trial, but I would suggest that you hire an attorney at this point. After the hearing, roughly 30 to 45 days, you're going to receive a notice of judgment and award. And this tells you the amount of money you owe, if anything. Sometimes it turns out that you don't owe anything, depending on the evidence. Once you receive this, then you know whether you have to pay some money or you don't have to pay some money. If you do have to pay money, then the labor board does have power of collection, or the employee can seek to collect. At this point, you'll also get the opportunity to appeal, but I don't typically recommend that, and let me tell you why. First of all, you have to have an appeal in 10 days, which means that you have to hire an attorney, and you have to put up a bond for the entire amount. So let's say the award is $100,000, just to make the math easy. That means you have to put up $100,000 as a bond just to appeal. Then your attorney files the appeal, which then becomes a Superior Court claim. Once it becomes a Superior Court claim, then the employee will likely hire an attorney. And almost any attorney would take one of these cases because very few of them win on appeal, about 10%. And if you lose on appeal, you have to pay all the attorney's fees on the other side. And the $100,000 is a bond, in a bond is already there for them to take. So typically, it doesn't make sense to do it unless you just have this great evidence and the hearing officer just didn't accept the evidence or didn't use the evidence to make their determination. But very few times do we want to do an appeal. If a judgment has been entered against you, then the best option, I think, is to negotiate with the employee. Try to work out a payment plan or a reduced amount or something that's going to make the blow much easier than it is. All right, so that's the nuts and bolts of a labor board claim. Until next time, be productive.